Hello, everybody. Welcome back to Ask Rusty Law. I'm your host, Rusty Messer, attorney with Big River Trial Attorneys. Thank you for tuning in. So today we are going deep on a federal law that a lot of maritime and waterfront workers have either never heard of or probably they have heard of it, but they don't fully understand it. So we're talking about the Longshore and Harbor Workers Compensation Act. It's also known as the LHWCA. And if you work on or around water, like maybe on a dock, in a shipyard, at a terminal, loading and unloading cargo, even performing maintenance on an oil rig, this law may be the most important piece of legislation that affects your life if you are hurt on the job. And yet, in my experience, a lot of workers don't really know their rights until after they've been hurt. So let's fix that today. First, a little history. The LHWCA is a federal law passed in 1927. It was passed because maritime workers were largely left out of state workers' compensation systems. So a lot of state workers' comp laws applied to land-based workers, but longshoremen, harbor workers, ship repairers, all these people were working in a no man's land, and legally speaking, they had very little protection. So the Supreme Court had ruled that state workers' comp laws couldn't cover injuries on navigable waters, but they were not considered Jones Act seamen either, so they were missing out on those protections. So Congress stepped in and it created a federal remedy. And it's been amended several times since then, with the biggest amendment, I think, back in 1972. So the law is administered by the U.S. Department of Labor, specifically through an Office of Workers' Compensation program. They call it the OWCP. And this is with the Division of Longshore and Harbor Workers. So, all right, let's get into the meat of it. So there are two big questions we need to talk about. One, who qualifies? And two, what can you recover? Let's start with who qualifies to bring a claim under the LHWCA. And there are two tests you have to meet. Courts call them Situs and Status. You have to satisfy both. So Situs is where you were injured. So the Situs test is about where the injury actually occurred. And under the Act, compensation is available for injuries that occur on navigable waters of the United States. But Congress understood that maritime work doesn't stop at the water's edge. So the Act also covers injuries on an adjacent pier, a wharf, a dry dock, in a terminal, maybe in a building, on marines, or sometimes even on the rails, or any other adjoining area customarily used by an employer in loading, unloading, repairing, dismantling, or building certain vessels. So think about that. We're talking about the waterfront, the docks, the terminals, the shipyards. If you were hurt in one of these locations doing maritime work, you may very well qualify under the Situs requirement. Now let's talk about status, and this is what kind of work were you doing? So the Act defines an employee as a person engaged in maritime employment. So this includes longshoremen, other persons in longshoring operations. It includes harbor workers. That includes ship repairmen, ship builders, ship breakers. Now, the law does carve out some certain categories of workers. And let me walk through these exclusions because they matter. The LHWCA does not cover people employed exclusively to do office, clerical, secretarial, security, or data processing work, as long as they are covered under a state workers' comp law. So just because you show up to a dock every day for your work does not mean you fall under the Act. It does not cover individuals employed by a club, maybe a camp, or recreational operation, a restaurant, or maybe even like a museum or like a gift shop. Again, if they have state workers' comp coverage. The Act does not cover employed by a marina. unless they're involved in construction, replacement, or expansion of the marina. So not just routine maintenance, like the maintenance worker on the marina wouldn't be covered. It does not cover individuals who are employed by suppliers or transporters or vendors who are temporarily on the premises. So if you're a truck driver making a delivery or something like that, as long as you are not doing maritime work, like the type of work that maritime employees normally do. It doesn't apply to agricultural workers. So if you're breeding fish or aquatic plants, you're excluded. It doesn't apply to individuals who build recreational vehicles under 65 feet in length or to repair any recreational vessel, again, as long as they're covered under a state workers' comp law. And it doesn't apply to a master or a member of a crew of any vessel because these people have a remedy under the Jones Act. It doesn't apply to any person who is hired to load or unload or repair a small vessel. And a small vessel is considered under 18 tons. Now, I want to pause on that last one, the exclusion for a master or member of a crew. And this is a critical distinction in maritime law. If you're a seaman, you are someone who has a substantial connection to a vessel that is in navigation, you have rights under the Jones Act, not the LHWCA. But if you're a longshoreman, a harbor worker, or maybe a ship repairman who is not permanently assigned to a vessel or a fleet of vessels, you're not a seaman. And the LHWCA may be your primary remedy. So the lines between these two categories can get blurry. And that is one place that a real maritime attorney earns their fee. I've seen cases where determining whether a worker is covered under the LHWCA or the Jones Act, or potentially both, was the central legal fight of the whole case. One other thing I want to talk about is the Outer Continental Shelf Lands Act, also known as the OCSLA. Under that law, the LHWCA is extended to cover workers on fixed platforms and other installations in the Outer Continental Shelf. So think of offshore oil and gas operations. This might be a worker on a drilling platform or a production facility, or maybe an artificial island doing repairs, maintenance, things like that. So you've been injured. You satisfy the Situs and the status test. Now, what can you recover? And the LHWCA provides several categories of benefits. So let's go through them. Number one, medical benefits, and this is foundational. Under the Act, your employer is required to pay for your medical, surgical, hospital services, medicine required, or equipment, and any treatment you need for your recovery. There is no cap on the medical benefits in terms of time. Your employer has to keep paying for reasonable and necessary medical care as long as you need it. Now, here's something important. You have the right to choose your treating physician. Now, there are some rules around that. The doctor has to be authorized by the Department of Labor. And once you make your initial choice, you usually cannot change positions, at least not without consent from maybe your employer or the court. But the point is, you're not forced to see just the company doctor. All right, number two, disability benefits. This is where things get very detailed. Disability benefits are based on your average weekly wages at the time of the injury. And the law sets different rates depending on the nature and severity of your disability, and they're adjusted annually. So there are four categories of disability under the LHWCA. You have permanent total disability. So you are totally and permanently unable to work. You receive 2/3 of your average weekly wages, so like just below 67%, and you get this for the duration of your disability. The law gives us some guidance here on what is a permanent total disability. There's a schedule, so if you lose both of your hands, your arms, your legs, or both of your eyes, or any two of those, you are presumed to be permanent and totally disabled. There's also a built-in cost of living adjustment for permanent total disability recipients. Let's talk about temporary total disability. If you're totally disabled but expected to recover, you again receive that 67% of your average weekly wages for as long as the total disability continues. So the first 3 days of your disability are excluded unless your disability lasts more than 14 days, in which case you get back pay to day one. So if you're considered disabled for 10 days, you'll only get paid for 7. But if you're disabled for 20 days, you'll get paid for all of it. So let's talk about permanent partial disability. This is the most detailed category in the Act. If you have a permanent partial disability, you receive, again, 66 2/3% of your average weekly wages, but for a set number of weeks. And it depends on what body part was affected. The law has a very specific schedule for this. All right, we're going to look at a few examples. The loss of an arm, 312 weeks of compensation. If you lose a leg, that's 288 weeks. Lose a hand, 244. If you lose a foot, that's 205. If you lose one of your eyes, that's 160 weeks. If you lose a thumb, 75 weeks. And loss of hearing in one ear is 52 weeks. Lose it in both ears, 200 weeks. This goes down through your individual fingers and your toes. Then there are injuries that don't neatly fit into the schedule. Let's say you have maybe a back injury or a shoulder injury. So the compensation is based on the difference between what you used to earn and what you're now able to earn. That's called a wage earning capacity determination. Usually you're going to need an expert to prove that. So now let's talk about temporary partial disability. If you can work, but at a reduced capacity while you recover, you receive 2/3 of the difference between your pre-injury average wages and your current wage earning capacity. And this is payable for up to 5 years. Now, there are some minimum and maximum limits on weekly compensation. So no compensation can exceed 200% of the national average weekly wage as determined annually by the Secretary of Labor. And a total disability compensation cannot be less than 50% of the national average weekly wage. Now, unless your own average wages were already below that, then you can get what your actual wages were. So this video is being shot in June of 2026. Right now, the average weekly wage is $1,041.35. The maximum weekly wage is $2,082.70. The minimum is $520.68. The amount that a worker can recover will depend on how much the worker was actually making before the injury. All right, number 3, vocational rehabilitation. If you are permanently or partially incapacitated, the Secretary of Labor can direct your vocational rehabilitation. This is helping you train for a new occupation. So while you're undergoing rehabilitation, you may receive additional maintenance compensation to help you cover for your living expenses during that time. All right, 4th benefit, death benefits. If a covered worker dies as a result of a work-related injury, the Act provides for death benefits to their dependents. And here's how it breaks down. You get reasonable funeral expenses up to $3,000, which are hardly reasonable these days, but that's what the law provides. A surviving spouse with no children gets 50% of the deceased worker's average weekly wage for life or until they remarry, which I would recommend against, at which point they receive a lump sum equal to 2 years of compensation. If there are also surviving children, the spouse gets 50% plus an additional 16 2/3% for each child, and it's still capped at 66 2/3% of the total wage prior to the death. If there's no surviving spouse, but there are children, one child gets 50% with an additional amount for each child. Again, this is capped at 66 2/3%. If there are other dependents, maybe like grandchildren, siblings, parents, there are certain circumstances where these people can receive benefits. All right, death benefits, like total disability benefits, also receive an annual cost of living adjustment. Now, I want to briefly touch on third-party liability because this is something workers sometimes miss. The LHWCA is an exclusive remedy against your employer. That means you generally can't sue your employer for pain and suffering, mental anguish, or things like that. But, and this is a big but, if a third party contributed to your injury, you may have a separate lawsuit against that third party in addition to your workers' compensation claim under the Act. So the classic example, you're a longshoreman, you're working on a vessel, and the vessel's equipment is defective, and this causes your injury. The vessel owner is a third party. That's not your employer. So you can bring a negligence claim against that vessel owner in addition to your LHWCA claim. Now, there are some rules about how your compensation and third-party recovery interact. There are subrogation rights, maybe assignment of claims, and so on. That gets very complicated very quickly. But the takeaway is don't assume your only remedy is under the LHWCA comp claim. Talk to an attorney who knows maritime law. Let me also cover the process of what happens after you hurt. First, you need to give notice of your injury to your employer. So the Act requires notice within 30 days of the injury or within 30 days of when you knew or reasonably should have known that your injury was related to your employment. For occupational diseases, you have 1 year from when you became aware of the connection. We see this a lot in asbestos claims. Second, you will need to file a formal claim with the deputy commissioner in your compensation district. So generally, that claim must be filed within 1 year of the injury or death. For occupational diseases, again, you have 2 years from when you became aware of the connection. Don't miss these deadlines. Missing them can bar your right to compensation entirely. So once a claim is filed, the deputy commissioner will investigate it, and a hearing may be held before an administrative law judge, so you do not get a full trial in front of a jury. If there's an appeal, this goes to a benefits review board, and further appeals can go on to the U.S. Circuit Court of Appeals. All right, one more thing to be aware of in the process are attorney's fees. Under the LHWCA, if your employer or your insurance carrier refuses to pay your claim, and you have to hire a lawyer to successfully litigate it, the law provides that a reasonable attorney's fee can be assessed against the employer or the carrier. And this is significant. It means that in disputed cases where you win, you may not have to come out of pocket for your attorney's fees. Those are paid by the other side. All right, let me bring it all home. The Longshore and Harbor Workers' Compensation Act is a powerful federal law designed to protect workers who make their living on and around our nation's waterways. If you're a longshoreman, a harbor worker, a ship repairman, or a shipbuilder, or you work in a terminal, or a dry dock, or if you work on a pier, you may have significant rights under this act that you don't even know about. Again, you can recover medical benefits, and this is all of them, for as long as you need. You can recover wage replacement benefits while you're unable to work. If you're permanently injured, you may be entitled to compensation for years to come. And if a third party's negligence contributed to your injuries, you may have an additional civil suit on top of that. And in that civil suit, you can still get pain and suffering, emotional distress, loss of enjoyment of life, and all of these other types of damages. Okay? But these rights do not enforce themselves. The insurance companies and the employers know the system inside and out. They hire lawyers that specialize in just this. So you need someone in your corner who does too. And not every lawyer does. So you need someone with experience in these types of cases. All right. Again, I'm Rusty Messer. This has been Ask Rusty Law. Thank you for tuning in. I hope you found this informative. Please like, please share, please subscribe. It helps the channel. Make sure to stay safe and stay informed, and I will see you next time.